this is a very little complex topic, and many of our clients they ask about this. So before we go detail, I just want to make sure that you understand this is a mathematical calculation. If you are not good in mathematics, it will be a little harder for you. This is a pure mathematical calculation. And also, I'll not go detail about like what is CSPA. I am assuming that you already know about CSPA, and then you're going to watch this video. Otherwise, a lot of things may not make any sense to you. Next slide, please. Okay, so what is CSPA? In short, like the purpose of CSPA is to protect certain children from aging out. So let me talk a little bit about what is CSPA, what is aging out kind of things. So in the family-based immigration petition, a lot of children, family-based immigration petition, sometimes it takes long time. Sometimes like it takes like a 14, 15, 25, 26 years to complete a application from beginning to end. So of course, there's a lot of dependents. They're very young child when they start the process, but when the process ends, most of the child they pass 21 year. So in American immigration law, a child is defined anybody who is unmarried and under the age of 21. So if you're married and if you age out, meaning if you cross the threshold of 21-year-old, then you are automatically get rid of from this immigration benefit. So this is a big issue for many families. That's why Congress tried to like solve this issue. Of course, they could not 100% solve it, but they tried their best. So this CSPA is a way to calculate your age to keep it under 21 if it is possible. So to do that, you can deduct two period of times from the entire from your age, and by doing that you can you can be eligible under 21-year-old. So we will go to that calculation and see how to how I'll try my best to explain it in a plain English. It's a mathematical calculation. Sometimes it maybe a little harder for you to understand, but I'll try my best. Next slide, please. All right, as I said, two time periods can be deducted from your age to see if you are under 21-year-old when you go and face the interview in the embassy or USCIS. Number one, before the approval of the application. This one is comparatively easy. And when I say approval of the application, I do not mean the end of the application. I do not mean that you are getting your green card. Approval of the application means when somebody apply I-130 for you or for your parents, somebody. So USCIS at first will send a receipt notice, meaning they received your application, like your relative's application. There's a receipt notice. And after sometime few days, sometime few months, sometime few years, they will approve the I-130. It doesn't mean that you're getting green card. They are just approving the I-130. And so before approval of that I-130 application, you can deduct this age. And then once your immigrant visa becomes available, like almost end of the process, then you can also deduct another time from your age. So we'll go that detail later. First, we'll talk about the before the approval of the application. Next slide, please. So, excuse me, I have a little cough. Sorry for that. So you can deduct the gap between receipt date and approval date. Let's say here there's an example. Let's say your relative filed application in January 12, 2021. So you get a receipt notice in, let's say, January 12, 2021 or 13, 14, 15, like within few days. And then finally, USCIS approves that I-130 in August 25, 2023. So there is almost 2.5 years gap between these two dates, priority date and receipt date. So you can deduct this time from your age. And by the way, here, approval date minus receipt date. There's a dash in between. This dash is like a minus. It's like a approval date minus receipt date. So in this case, approval date is August 25, 2023 minus January 12, 2021. So this age you can deduct from your age. Next slide, please. All right. How about after the immigrant visa becomes available? And this become available is a tricky term. I'll talk about this. So This is and in this kind of situation there is a two scenarios. Number one, in the embassy, meaning consular process, meaning let's say your relative applied for I-130, I-130 got approved, and you and your parents, you live in a foreign country, let's say in India or Pakistan or Nigeria. And then once your case goes to NVC, and then documentarily qualified, you just keep waiting. At one point your priority date will be present in the visa bulletin. So if it is in the embassy, meaning consular process, then age freezes when your priority date becomes current in the final action date for family sponsored cases box. So I assume you already know about visa bulletin. So in the visa bulletin, there's two major categories. One is for family-based application, one is employment-based application. In the family-based application category, there's another two boxes. One is called final action dates for family-sponsored preference cases. Another one is date for filing. So for the purpose of consular process, for the purpose of embassy, your age will freeze when your priority date is current in the final action date box, not the other box, final action date box. So let's say your priority date is current today, and then your interview is 1 year from now. So even though you are waiting more than a year after your priority date is current in the visa bulletin, your age will freeze today. So you can deduct this age from today to the date of interview. So your age will freeze today. This is for the scenario of embassy. Next slide, please. However, if your case is in the USCIS, so this is the most complicated part of the CSPA calculation. So if you and your family member, you live in America, and your I-140 got approved long time ago. Now this is time for I-485. In the scenario of USCIS, the appropriate form is I-485. If you file I-485, if you or your family member, then the applicable term is becomes available. So this become available can either be final action date or date for filing. I just told you that there's two boxes under family-based categories. One is final action dates, another one is date for filing. So it can be either of those. So how do you know? So there is a page in USCIS website. It's called Adjustment of Status Filing Charts from the Visa Bulletin. Adjustment of Status Filing Charts from the Visa Bulletin. If you go to that page, USCIS will tell you which chart they are following for the purpose of determining becomes available. And they will tell about the current month and the next month. So which chart you will follow will be determined by the USCIS at the time. So you cannot predict upfront. USCIS changes this thing every month, so you have to check your visa bulletin every month. I know it's a lot of hassle, but this is the work you have to do to get the green card. So number one, CSPA is complex. Number two, this part, especially if you are applying for I-485 adjustment of status from within America, your age will freeze when your visa become available, and when the visa will available can be either of the two boxes, and it will be determined by the USCIS in that month. I'll give you another example very soon. Next slide, please. Okay, so now, I try to make it like a mathematical rule, kind of like a summary of these two situations. Number one, you can deduct approval date minus receipt date in the upfront. That is applicable to all scenarios. And then in the second scenario, if it is IVP, immigrant visa petition or consular process, then the mathematical rule is today's age minus when your priority date becomes current in the final action date box, minus, and then this part is within the bracket, within the parenthesis, within the bracket. So you have to minus it first and then minus from other age, minus approval date minus receipt date. I'm saying again, today's age minus when your priority date becomes current in the final action date box, and minus approval date minus receipt date. And if after all this calculation, if it is within 20-year-old, if you're under 20-year-old, then you are qualified for green card. I know it's a little complex. Now let's go to the second scenario, which is adjustment of status I-485. The rule is today's days, when immigrant, I mean, today there should be like apostrophe. Yes, I'm sorry, there's like some typo here. Today's days minus when immigrant visa becomes available. Again, this visa available depends on the USCIS every month, minus approval date minus receipt date. So this is the calculation. It's hard for me to explain without um, getting more data, but this is the rule. So that was our presentation about child CSPA, Child Status Protection Act. I hope I tried my best to make it clear, but if you have any question, I'll be happy to answer.